If you have a legal dispute, it is likely to go to mediation. I want people watching this video to feel confident about dealing with disputes. So I made this video to arm you with the knowledge you need regarding what mediation is, the process involved in mediation, and what you can expect if your dispute goes to mediation. I hope you and yours are doing well. Let's dive right into this important topic. The mediation process is often misunderstood by the participants, and such misunderstandings can cause mediation to be less effective than if the parties see mediation for what it is, an opportunity to resolve the dispute out of court. I'm going to explain the mediation process and the benefits of mediation, so when you have a case that goes to mediation, you will be informed. People often ask, what is mediation? It's a method of alternative dispute resolution, also called ADR. You can think of a mediation as a good faith effort by the parties to get together to try to settle their dispute. Mediation is essentially a confidential negotiation and a series of communications between the participants facilitated by a mediator. Did you know that most judges require cases to be mediated before they will rule in favor of either party or proceed with the case? At mediation, the parties are under no obligation to settle the dispute, but they are obligated to participate in the mediation. You may ask, what does the mediator do? The mediator is neutral, leads the mediation, and acts as a go-between for the parties to the mediation. Usually, but not always, the parties are involved in selecting the mediator, and the mediator's fee is paid by the parties. The mediator's role is to explain the mediation process to the parties and to get them to participate in the mediation. The mediator's main objective is to help the parties reach an agreed-upon resolution of the dispute. After the mediation, the mediator usually prepares a certificate to be filed with the court stating the parties have mediated the case. Before a mediation, my clients often ask, what is the mediation process? After getting the parties' agreement to the ground rules, the mediator will have each party briefly present its contentions uninterrupted. Usually, the party asserting a claim will be designated as the claimant or plaintiff, and that party presents its contentions first, including the remedy sought, which is usually the payment of money by the other party. In some cases, money is not the remedy. In such cases, the remedy may be for the other party to take some action or to cease doing something the claimant doesn't want them to do. After the claimant makes its initial statement, the other party is entitled to an uninterrupted response, after which the parties separate into different rooms so the mediator can speak confidentially with each of them. The mediator typically takes the claimant's first settlement offer to the other party and privately encourages the party that received the offer to respond or make a counteroffer. While going back and forth between the parties with offers and counteroffers, the mediator also shares his usually more realistic assessment of the dispute. There's something special about the process of the mediator candidly and confidentially discussing his assessment of the particulars of the dispute with each of the parties and pointing out the risks and disadvantages of continuing the dispute to the bitter end. It's that candid assessment, which often includes issues not considered by the parties' attorneys, that enables the participants to become more realistic in their expectations regarding the likely outcome of the dispute. This process is called helping the parties determine their best alternative to a negotiated agreement, also called Batna. A party's Batna is simply the likely course of events that will occur if the parties do not settle the case. Many times, getting a party to see that its Batna includes significant risks and attorney's fees causes a party to view a settlement more favorably. While the parties to mediation are under no obligation to settle their dispute, it behooves them to earnestly try to reach a settlement through mediation because the reality is most legal disputes are eventually settled outside of court. Most mediators I've dealt with really like to help people settle the disputes they mediate. And my clients have been pleasantly surprised when their case is settled during the mediation, where at the beginning of the mediation process I had thought mediation would be futile. because the parties seemed too far apart, or because the parties were really angry. Now you know what mediation is. You know the process, and you know what to expect at a mediation. Hopefully you see mediation for what it is, a process that may result in a settlement if the parties participate in the process. Be on the lookout for my next 2 related videos on arbitration and what including an arbitration clause in your contract could mean for your business. So long for now.